Part 3 is going to be a doozy. If this is too long, just skip over to part 4. I will have a shorter summary, but I thought it was interesting to hear the whole thing.
You're converting the restriction on ByteDance's ownership of the algorithm and the company into a restriction on TikTok speech. So why can't we simply look at it as a restriction on ByteDance?
Because I think the burden falls directly on TikTok, and I can use a hypothetical that helps illustrate the point. Suppose that China used its leverage over Jeff Bezos' international empire, including his Chinese businesses, to force the Washington Post to write whatever China wanted on the front page of the Post. Surely the government couldn't come in and say, Jeff Bezos, you need to either sell the Washington Post or shut it down. That wouldn't just violate Mr. Bezos' First Amendment rights. That would also violate the Washington Post's First Amendment rights, because they are ultimately the one that's suffering the burden under that law, because they have to go dark and close up their books.
Counsel, you began by saying this is a U.S. company operating in the United States.
Yes, Your Honor.
But the ultimate company that controls it, ByteDance, was found by Congress, and I quote this, to be subject to Chinese laws that require it to assist or cooperate with the Chinese government's intelligence work, quotes, and to ensure that the Chinese government has the power to access and control private data that the company holds. So are we supposed to ignore the fact that the ultimate parent is in fact subject to doing intelligence work for the Chinese government?
Well, Your Honor, I don't think you are supposed to ignore that at all, but I also don't think that it changes the analysis for a couple of reasons. Look, TikTok and—
Well, just hold a second. Well, as I said, you began by saying this is a U.S. company operating in the United States, and it seems to me that you're ignoring the major concern here of Congress, which was Chinese manipulation of the content and acquisition and harvesting of the content.
Sure. And I'll start by saying that TikTok Incorporated is a United States subsidiary operating in the United States with its own set of free speech rights.
Do you dispute the fact that ByteDance has ultimate control of TikTok in its corporate organization?
Yes, Your Honor, I do dispute that, but I also don't think that it matters, because even if China could exercise overwhelming power against TikTok versus ByteDance, I don't think it would change the analysis. And I can take that Washington Post hypothetical and ratchet it up a little bit to help illustrate the point. Let's suppose that the Chinese government had actually taken the Bezos children hostage, and it was using that leverage in order to force Bezos and the Washington Post to publish whatever they wanted on the front page of the Post. So China effectively has total control. I still don't think that Congress could come in and tell Bezos either sell the Post or shut it down, because that would violate Bezos's rights and the Washington Post rights. Maybe what they could do is come in and say, you need to disclose the fact that you're under this amount of coercion, so that the people who are looking at the paper understand it and can make their own assessment. But I think the First Amendment rights of both Bezos and the Post would be directly implicated, notwithstanding that China in that scenario has effectively total control over what gets printed in the Washington Post.
Counsel, let me break this down. I understand your argument that there is a First Amendment right that the U.S. company has. I'll go that far with you, okay?
I'll take it.
Because we're affecting their ability to talk in whatever way they choose. The Washington Post could choose without any influence or threat against the children of Mr. Bezos to promote Chinese policy, and our First Amendment would permit them to do that if they chose it independently, correct?
Yes.
Now the question becomes, so it's not, that's just a given that they have a First Amendment right. The next question is, assuming they do, what's the level of scrutiny we apply? Isn't that what the issue here is?
That is certainly one of the issues, Your Honor.
All right. So if we get to that side of the issue, that TikTok USA has some sort of First Amendment right, taking your example, if the government said no speaker is free to speak under a criminal compulsion by someone else because of extortion, because of kidnapping, we are doing this because it is the only way to ensure the safety of people, that they are not going to be kidnapped or threatened, their lives threatened. You don't think that the government has a compelling state interest in saying, if there is a threat, a physical criminal threat against someone to do some activity, that the government couldn't say, I'm not questioning whatever the content is of that activity. I'm simply saying we, in our governmental powers, have a right to say, you can't do that. You can't speak.
Sure, Your Honor. So to take your question in pieces, I do think that they would have a compelling interest in that scenario to do something. But what I don't think is that they could simply target speakers in speech. Take, for example, generally applicable laws like the
So
trading.
you think in that situation that the only thing the government could do is tell the Washington Post, disclose to the public that you are saying this because you are being forced to?
So, sure.
That's the only remedy the government could undertake?
No, Your Honor, but I want to make sure I understand the hypothetical. The compelling interest is in preventing this kind of compulsion, coercion, and ultimately harm to children. And I think that the government has a lot of different ways they can address that through speech-neutral laws. And I was going to point to things like the Trading with the Enemy Act or Russia sanctions. You can broadly say and attack problems.
They haven't been very effective.
Well, be that as
we're still having people kidnapped, we're still having coercion.
And be that as it may, you can say to Americans, you cannot collaborate with our enemies at all, and if you do that, you're going to be severely punished for doing
All
that.
right, we can
But what I
go
don't-
on to the effectiveness of the remedy, but the point is, I believe, that even if your First Amendment rights are impinged and there is some protection, the question is at what level of scrutiny?
Yes, Your Honor.
And whether that the action is content neutral or not.
I agree that that is the way that the analysis proceeds. Here, we believe that the level of scrutiny should be strict scrutiny.
What is the relevance of the history? Chief Judge Srinivasan, in his opinion, in the D.C. Circuit, emphasized that there is a long tradition of preventing foreign ownership or control of media in the United States, going back radio, television, and what have you. I would think no matter the level of scrutiny, that history has to be
That one doesn't make any sense because it has to do with limited licenses to be able to give out like limited bandwidth. Anyways, tell me what you guys thought of that. If you stuck with me through the whole thing, dude, rock on. You can skip part 4 since you already heard that in depth. Look out for part 4, and we're about to get into some really interesting stuff. And it does start off seeming like they are very against stopping the ban, but I felt a lot better by the end.